Hello everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. In this video today, I'm going to discuss with you all mock test number 21. Exclusively this series for mock tests has been started at LegalBee. I'm going to deal with CPC today. This is a subject-wise series in which each subject we are picking important topics and discussing questions out of that. So ऐसी series आपको कहीं पे भी नहीं मिलेगी जहाँ पे आपको mock test मिल रहे हैं, important topics, important provisions पता चल रहे हैं topic-wise daily at 11 a.m. on LegalBee only. So don't forget to subscribe to our YouTube channel and if you have any queries or else you require any guidance on any exam preparation, be it judiciary, be it SEBI, be it any examination which you can give after law, don't forget to subscribe to LegalBee and write to us at hello@iexambee.com, or you can also call on the number that is there on the screen. You can also visit our website www.iexambee.com for the same. So let us quickly start with our new topic for today, and this is the last topic that I am going to cover from Code of Civil Procedure. I will be picking some questions from important orders and rules from CPC. ये जो part है काफ़ी static part लगता है students को, so ये video आपके लिए काफ़ी beneficial रहने वाली है. इसमें से मैं कुछ इंपॉर्टेंट ऑर्डर्स एंड रूल्स डिस्कस करने वाली हूँ एंड उससे क्वेश्चंस डिस्कस करने वाली हूँ. आप इस पीपीटी को भी डाउनलोड कर सकते हैं एंड यू कैन कीप इट विद यू फॉर योर रेफरेंस. सो द फर्स्ट क्वेश्चन विल बी where the court orders service by an advertisement in a newspaper, a daily newspaper circulating in the locality in which the defendant is last known to have actually and voluntarily resided. This is an important provision from summons. Summons एक काफ़ी important order भी है and ये practically काफ़ी important question है. जो लोग practice कर रहे हैं उन्हें इस बारे में ज़रूर पता होगा. So the options are substituted service, personal service, residuary service, service on the defendant's agent, service when the defendant cannot be found. It is actually an easy question. Answer is A. It is known as substituted service, covered under Rule 20 of Order 5. Very important provision. This is substituted service. Court is satisfied that the defendant is keeping out of the way for the purpose of avoiding service and the summons cannot be served in the ordinary way. And 1A जो है इस rule का, that is the court can order advertisement in newspaper, service by an advertisement in newspaper, जो paper publication कहा जाता है, जिसे काफ़ी common mode है ये service of summons का. Service of summons by affixation on some conspicuous part of the house when the defendant refuses to accept the service of summons is provided under which rule of Order 5 of CPC? Now this is a provision based question. Judiciary and all exams में आप ऐसे section based, provision based questions expect कर सकते हैं and ये important provision है and इस पर आप दूसरे भी questions expect कर सकते हैं. That's why I've taken this over here. You need to remember this rule as it is very important one. वैसे generally rules से इतने questions नहीं आते, लेकिन अगर काफ़ी important है so I would suggest कि आपने rules भी cover करने हैं. Covered under Rule 17, procedure when the defendant refuses to accept service or he cannot be found. So, the summons can be fixed on some conspicuous part of the house of the defendant or where he works, resides permanently or temporarily he is working for gain business. उस area के कोई outer door पर summons को fix करना होता है and you have to take the bailiff has to take signature of a witness for the same and submit report as well. When there are several defendants, service of summons shall be made. Several defendants के केस में क्या किया जा सकता है? Service of summons will be made on each of the defendant or any two of the defendants personally, or all of them will be served with the summons jointly, all of the defendants jointly, each of the defendant jointly, each defendant and also all of them jointly. मतलब ये options काफ़ी confusing लग रहे हैं, वैसे concept बहुत simple है. And the answer is A. On each of the defendant, service on several defendants का direct provision भी है हमारे पास Order 5 Rule 11 में, where there are more defendants than one, service of the summons shall be made on each defendant. When service of summons has to be made on the defendant and he is absent from his residence, not likely to return in a reasonable time, तो क्या किया जा सकता है? समन्स काफ़ी इम्पोर्टेंट टॉपिक है सीपीसी से। ये सारे ऑप्शंस हैं। अडल्ट मेंबर पर दे सकते हैं समन्स, अडल्ट मेल मेंबर को दे सकते हैं, इंक्लूडिंग सर्वेंट, एक्सक्लूडिंग सर्वेंट, अडल्ट मेल मेंबर ऑफ द फैमिली और हिज वाइफ। किसको समन्स दोगे अगर आपको ऐसा पता चलता है दैट ही इज़ आउट ऑफ टाउन सपोज, एंड वो रीजनेबल टाइम में वापस नहीं आने वाला है डिफेंडेंट? सो इट कैन बी मेड अपॉन द एनी अडल्ट मेंबर ऑफ द फैमिली. Order 5 Rule 15 exclusively talks about it that service can be made on any adult member of defendant's family, and उसमें servant नहीं आता है, that is there in the explanation clause. but हमने यहाँ पे ये ऑप्शन क्यों नहीं पिक किया है any member of the family excluding servant? because adult word वहाँ पर नहीं है. अगर यहाँ पर डी ऑप्शन में अगर adult word होता तो हम लोग डी ऑप्शन को चूज करते. Plaint shall state precisely the amount that is claimed in all money suits except the amount for. Now this is relating to drafting of a plaint. Can anybody guess the order number in which plaint is being discussed exclusively? I would suggest that you write in the comment section of this video. वैसे तो आपको वो solution में भी मिल जाएगा, but still तब तक plaint shall state precise the amount claimed in all money suits except the amount for. Means profit, amount due from unsettled accounts, movables that are in possession of defendant, both means profit and amount due from unsettled accounts, या फिर movables in possession of defendant as well. plaint में अगर आप मनी सूट फाइल कर रहे हो तो plaint में कितना अमाउंट आपको प्रिसाइजली मेंशन करना है और किस से रिलेटेड मेंशन करना है? इट इज़ गोइंग टू बी ऑल ऑफ द अबव. ये कॉमन लॉजिक बेस्ड क्वेश्चन है. अगर आपको नहीं भी पता है, यू कैन अप्लाई योर लॉजिक, because you have to include all the points that are relating to your cause of action precisely in the plaint. Order 7 deals with plaints. Order 8 deals with written statement. Order 6 deals with pleadings. And money suits के लिए exclusively rule 2 है, उसमें ये सारे points दिए हैं जो हमने options में cover किए. Next question. If the suit was not instituted in the proper court, plaint can be rejected. Plaint can be returned to the plaintiff with endorsement. Plaint shall be returned to the appellate court for forwarding it to the proper court. Plaint shall be returned to the proper court with endorsement and reasons recorded. Plaint shall be rejected for lack of jurisdiction. Now this is a very beautifully drafted question. As the options you can see, they are making the question confusing. So you have to read it very carefully and answer. It is easy, but the options are of such a nature that they are giving it a look that it is difficult, but actually the question is easy. If your basic concept of rejection of plaint, return of plaint is clear. So this is D. Plaint shall be returned to the proper court with endorsement and reasons recorded. इस channel से ही plaint जाएगा. Order 7 Rule 10 deals with return of plaint, and according to that the plaint where it is there, the court where it is actually filed is not having the jurisdiction, so it will not directly reject it. It will send it with endorsement and reasons to the proper court. That is return of plaint. Return of plaint can be done only before the issues are framed, at any stage of the suit, before the evidence is recorded, after judgment is passed, till the preliminary issue is framed and decided. So return of plaint can be done when? Stage. At what time it can be done? Answer is B. At any stage of the suit you can return a plaint, because at the time you understand that the jurisdiction is not proper, though the preferably it should be decided as a preliminary issue only. But if in case the court gets to know later, then also court cannot continue further. At any stage of the suit, if the court gets to know about it, it has to be returned immediately. Rule 10 deals with return of plaint, उसमें ये impliedly covered भी है. Next question. Amendment of a pleading can be permitted at any stage of pleadings, at any time before the trial commences, except if the court comes to the conclusion that parties could not raise it earlier with due diligence, at any time before issues are framed, at any time before judgment is passed, at any time just after the summons are served to defendant and issues are not framed. अब ऐसे स्टेज वाले जो क्वेश्चंस है ना, ये कभी कभी कंफ्यूजिंग हो जाते हैं. अमेंडमेंट ऑफ प्लीडिंग्स होता है, ये सबको प्रैक्टिकली पता होता है, बट उसका प्रोविजन कहाँ है सीपीसी में, वी डोंट नो दैट. So that is where we are lacking, and for competitive examination preparation we have to be very specific with the provisions as well. so that we are able to have the full knowledge of that area and not half knowledge. And the stage exactly when you can make amendment of a pleading, when it can be amended, because अगर issues frame हो गए तो आप amend कर सकते हो क्या? Actually इस पे काफ़ी liberal approach होता है court का. At any time before the trial commences, except with the court comes to the conclusion that parties could not raise it earlier with due diligence. This concept is similar to like that of limitation. जैसे सफिशिएंट कॉज हो तो कंडोन हो जाता है डिले, भले वो 10 साल का क्यों ना हो. सिमिलरली अमेंडमेंट कैन ऑल्सो बी ग्रांटेड इफ सपोज ड्यू डिलिजेंस वॉज अप्लाइड बाय द पार्टीज बट दे कुड नॉट हैव अर्लियर अमेंडेड इट. So if the court is satisfied, then the court can allow at any time before the trial commences. वैसे general provision. This is covered exclusively under Order 6. Order 6 deals with pleadings. In that, Rule 17 governs amendment of pleadings. आप इसको मार्क करके रख लीजिए या कहीं लिख लीजिए, because generally हम ऐसे provisions भूल जाते हैं या हमें पता नहीं होता है. Amendment of pleadings होता है, we know that, but the provision also we need to remember. Order 6, Rule 17 deals with amendment of pleadings. Subsistence allowance has to be paid by decree holder. Now this is the question relating to execution now. Subsistence allowance has to be paid by decree holder. If not paid, judgment debtor shall be released. Judgment debtor shall not be arrested. Judgment debtor shall not be provided food in civil prison. Decree shall stand abated. Execution proceedings shall be stayed. अगर subsistence allowance नहीं दिया जाता है तो क्या consequences हो सकते हैं? This is also a very interesting question, I would say. हमें ये पता है that the decree holder has to pay for the charges of the judgment debtor being in the jail. But if he does not pay it, then what will be the consequences? That also we have to know. Order 21 execution से deal करता है. In that, Rule 39 deals with subsistence allowance. No judgment debtor shall be arrested in execution unless and until decree holder pays into the court the sum as the judge thinks fit. यानी कि ये sum पहले ही भरना होता है before the judgment debtor is arrested. And ऐसा कुछ नहीं होगा, ये ऑप्शन जैसे है ये हम देख के ही समझ सकते हैं. नॉट प्रोवाइडेड फूड इन सिविल प्रिजन, ये सब इस तरीके के प्रोविजंस हमारे पास नहीं हो सकते. डिक्री भी अबेट नहीं कर सकते हम लोग. सो व्हाट इज समथिंग विच इज लॉजिकल इज दैट ही विल नॉट बी अरेस्टेड ओनली. Means that mode of execution will not be exercised. Now the last question for this CPC topic from the series: in case of a decree for execution of a document, draft of the document shall be prepared by judgment debtor, decree holder, court A or B, B and C. अगर एग्जीक्यूशन ऑफ डॉक्यूमेंट की कोई डिक्री है, फॉर एग्जांपल नेगोशिएबल इंस्ट्रूमेंट से रिलेटेड है, या कोई भी डॉक्यूमेंट पर भी एग्जीक्यूशन होता है, इस तरीके के सूट्स भी होते हैं. सो एट दैट टाइम द एग्जीक्यूशन मोड इज डन बाय ड्राफ्टिंग द डॉक्यूमेंट फर्स्ट, एंड दैट हैज टू बी डन, एंड देन बिफोर द कोर्ट दैट डॉक्यूमेंट हैज टू बी एग्जीक्यूटेड. बट देन हु विल ड्राफ्ट दैट पर्टिकुलर डॉक्यूमेंट? नाउ दिस इज अ प्रोविजन विच इज अ वेरी डीप क्वेश्चन दैट हैज बीन आस्क्ड. सो आई हैव टेकन दिस क्वेश्चन पर्पजफुली so that I make you aware that such kind of questions also you have to be aware of. Answer is B, decree holder. Always decree holder will only be have all the responsibility while execution. This is something which is the truth. Even if there is a decree in his favor, he only has to take the efforts for all the time realization of the decree. Order 21 deals with execution. Rule 34 deals with decree for execution of document और एंडोर्समेंट ऑफ अ नेगोशिएबल इंस्ट्रूमेंट. अब यहाँ पर क्वेश्चन में एंडोर्समेंट ऑफ नेगोशिएबल इंस्ट्रूमेंट भी हो सकता था. जो लोग बैंकिंग एग्जामिनेशंस के लिए प्रिपेयर कर रहे हैं, लॉ ऑफिसर एग्जाम्स के लिए प्रिपेयर कर रहे हैं, आई वुड सजेस्ट दिस क्वेश्चन इज वेरी इंपॉर्टेंट फॉर देम एज दे नीड टू हैव आइडिया ऑफ दिस प्रोविजन. प्रैक्टिकली ऑल्सो इट इज वेरी इंपॉर्टेंट दैट while execution, the endorsement of the negotiable instrument will be done by whom? It will be done by the decree holder. Decree holder has to endorsement means the draft for that particular document or endorsement has to be made by the decree holder. Rule 34 of Order 21 of CPC deals with this. So this was all that I had to discuss today with you all. Some important orders and rules. Like this, you need to pick the important provisions from CPC. Also, I would like to give you an update about the judiciary test series, the mock test course that we are having. And 2 tests you are getting every week at iExamBee. So don't forget to visit www.iexamBee.com. Download the entire test plan. It is a 6 months course, and in that you will get 1 live class also for your doubt clarification on mains question answer writing. Also you will get skills developed. So ये course काफ़ी अच्छा है, आप visit कर सकते हैं अगर आप judiciary के लिए prepare कर रहे हैं. So it will be beneficial for you. Check out all the details. And other than that, we have a we have planned a free workshop at iExamBee's LegalBee exclusively with Robin Dutt sir, who is a practicing advocate, experience of more than 25 years at Punjab and Haryana High Court and the Supreme Court of India. So he is going to guide the students relating to litigation, judiciary and the career after law basically. So ये free guidance session है. So if you want details, you can take all the details of that, and stay tuned with LegalBee for all the regular updates. Don't forget to subscribe and prepare 50% faster with iExamBee. Thank you.